So in this video, we're going to talk about a new suppressor law, which was passed, signed into law, and which is currently using the Texas Suppressor Freedom case and those current attempts to stop the NFA and ATF regulation of suppressors. So let's talk about what is going on. But real quick before we jump into this video, if you think we need to remove all these restrictions on suppressors, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I carry the Kershaw Iridium knife every single day in my EDC, and I cannot recommend them enough if you just want a quality, durable, and just a knife you can rely on every single day. And right now, if you go over to Kershaw and you order and you use the code YT20Scholar, you can get 20% off of your order and free shipping on orders of $50 or more, and that will last until the end of December. So head on over to Kershaw, pick yourself up a quality EDC knife, and again, thank you to Kershaw Knives for supporting this 2A content. As I mentioned in the intro, in this video, we're going to be discussing a law which was passed in the state of Mississippi and which is essentially piggybacking off of the Texas Suppressor Freedom lawsuit and those current attempts in Texas in the Fifth Circuit to eliminate the NFA and ATF's regulation of made in Texas suppressors. This Mississippi law, in combination with the Texas Suppressor Freedom lawsuit, aims to create a state-by-state movement which will essentially deregulate these suppressors which are made and stay exclusively within certain states. Now, the Mississippi law that we're going to be talking about in this video is HB 912. HB 912 was sent and signed by the governor in Mississippi earlier this year. Honestly, I had no idea that this law was even happening until some of my viewers on the recent Texas Suppressor Freedom case, the video that we put out, they mentioned this Mississippi law, told me to look into it, and I was surprised to see that another state was trying to piggyback off of what Texas was doing. Now, the purpose of the law in Mississippi is to provide that a firearm suppressor manufactured and remaining in the state of Mississippi is not subject to federal laws and regulations governing firearm suppressors. The law goes on to prohibit state and local government authorities from enforcing federal regulations on suppressors made in Mississippi. The law requires that state funding must be withheld from any government agency in the state that adopts a rule or policy which would help in enforcing a federal suppressor law. The law then goes on to also remove a bunch of state criminal codes in a bunch of criminal code sections, which essentially involve the possession of suppressors. And so they're saying maybe if you possess these made in Mississippi suppressors, then you would potentially not fall under some of these criminal codes. In essence, the goal of the Mississippi law is to copy what Texas did with their Texas Suppressor Freedom law and apply it to their specific state. The law, however, is completely structured in a way that it is contingent and tied on the outcome of the current Texas Suppressor Freedom lawsuit, which is Paxton v. Dettelbach. The Mississippi law, although passed and signed, actually states that it will not take effect until the Texas lawsuit is resolved by the Fifth Circuit and eventually by the Supreme Court. Now, for those not aware, the Texas lawsuit, which is referenced in the Mississippi law, arises out of Texas House Bill 957, which passed back in 2021, I believe. HB 957 aimed to exempt from federal regulation all suppressors that are made in and remain within the state of Texas. The claim behind this law is that since these items are made and sold exclusively within the state of Texas, they do not fall under interstate commerce, and therefore they fall outside the purview of federal regulation by the ATF. Now, after Texas passed this law back in 2021, the ATF sent out a warning letter threatening that they would in fact enforce the NFA and GCA's regulations and restrictions against these made in Texas suppressors. And as a result, Texas, along with some individual plaintiffs, sued the ATF. This case was then submitted to a federal district court in Texas, the Northern District of Texas, and it was submitted to the judge on cross motions for summary judgment. Well, after reviewing the case, the district court judge granted the motion for summary judgment in favor of the government, in favor of the ATF. The court ruled in favor of the government under the rationale that the plaintiffs in the case lacked standing to bring the lawsuit. Well, in this decision, the lower court judge stated that the parties only contest whether plaintiffs have suffered an injury in fact, again, one of those elements for standing. And on review, the judge found that they had not suffered an injury in fact, and therefore the plaintiffs in the case have no standing. The judge stated in the Texas case that individual plaintiffs are correct, that the government has a history of prosecuting the illegal possession of unregistered silencers. But these plaintiffs have adduced no evidence that they in fact possess any illegal silencers or otherwise attempted any prohibited conduct, nor have they shown that they have been threatened with prosecution or that it is likely. And our doctrines of criminal law forbid convicting persons from mere thoughts, desires, or motives. Individual plaintiffs therefore fail to allege a substantial risk of prosecution based solely on the desire to do something the government has prosecuted in the past. So individual plaintiffs' fear of prosecution is imaginary or speculative at best and insufficient for Article 3 standing. There, the judge in the case is essentially stating that the individual plaintiffs in Texas would have to allege that they possess an illegal silencer or that they have engaged in some sort of prohibited conduct that the ATF claims is in fact illegal. The court also claimed that the plaintiffs could show standing through the evidence that they have been directly threatened by the ATF or that they went through the process to try to register one of these Texas-made suppressors with the ATF. The position the judge takes in this case is that the showing of intent is not enough, that you would actually have to engage in the conduct or potentially violate the law to show standing. Instead, you would also need potentially some sort of plaintiff who decides to fall on their sword, kind of take one for the team and engage in this illegal conduct so that they then had standing to sue the ATF. And then finally, in this Texas case, which Mississippi is relying on, the lower court judge stated that also there was no standing by the state of Texas itself to sue the ATF. They argued that the state of Texas could not sue on behalf of their residents. And based on all of that, the judge granted the government's motion for summary judgment and dismissed the entire case. And again, that was a ruling in favor of the ATF. Now, in response, Texas has now asked for the Fifth Circuit Court of Appeals to review and reverse that lower court's decision and to reverse what they said about standing. In their recent brief to the Fifth Circuit, the state of Texas stated that this case warrants oral arguments because it raises issues of exceptional constitutional importance. Do Texans have standing to challenge the constitutionality of those statutory requirements before applying for permission and paying the tax? And does Texas also have standing to vindicate its quasi-sovereign interests in its citizens' health and safety? Now, I know in the past when I've covered this Texas Suppressor Freedom case, some people have commented, well, this doesn't really matter for me. Maybe you're in Montana or some other state. Some people believe that this Texas Suppressor Freedom case only applies to the state of Texas, and that's not really true. The Texas case is now being reviewed by the pro-Second Amendment Fifth Circuit Court of Appeals. There's been a lot of decisions coming out of the Fifth Circuit and some of those lower courts which have impacted a lot of things nationwide. And then also remember, there are more states than just Texas which are under the Fifth Circuit. And then now you have some of these other states like Mississippi, which are trying to be proactive and kind of piggyback off of this Texas law and piggyback off of this lawsuit. And ultimately, this is one of those cases which will, I think, eventually make its way to the Supreme Court, at least request Supreme Court review. And then, of course, any decision by the Fifth Circuit and any decision by the Supreme Court will have broad application going forward for a bunch of other 2A cases and really could open the door for more states, maybe even your own state, to pass a law which is similar in nature to what Texas did and Mississippi is doing, which deregulate suppressors on a state-by-state basis. Again, some states like Mississippi are already being proactive and have already passed state-level laws which are trying to piggyback off of the Texas law and take effect immediately once the Supreme Court or the Fifth Circuit upholds this case. Now, in Mississippi HB 912, it states that this act shall take effect and be enforced from and after the date that the United States Supreme Court rules in favor of the Texas Attorney General and the state of Texas and its passage and implementation of Texas House Bill 957. And then it talks about also the specific case, Paxton v. Dettelbach. So the Texas Suppressor Freedom case has huge ramifications going forward for the potential state-by-state deregulation of these types of suppressors and other items. But I just want to remind everyone, just in case, that right now the ATF still treats these items as regulated and subject to the NFA and GCA's restrictions, and they will still go after people who engage in this type of conduct if you don't file a Form 1, if you don't follow the proper procedures. So again, keep that in mind. Also, for those of you in Mississippi, if you're watching this, your state law is not active until the Paxton case is resolved. So again, keep that in mind. Now again, hopefully the Fifth Circuit gives us another Pro 2A win, and then maybe we get this case up for Supreme Court review. Of course, if we get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. And then also I want to mention that we do have a podcast available. If you're interested in listening to the podcast, I will leave links down below to the audio formats. It's available on Apple, Spotify, Amazon Music, Pandora, really anywhere you listen to a podcast, Google Podcasts, you can get it. And again, some of the links will be down below. But regardless, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.